Thank you. This is a very important hearing to make sure that people get justice. Since our last hearing, the Office of Personnel Responsibility has released its report. You've talked about that, so I'm going to skip that part of my remarks. You talked about the second review, and I'm going to skip that part. I'm going to go to saying finally, we have the review of the OPR's findings by Terrence Berg, a career prosecutor assigned to the Professional Misconduct Review Unit. Berg was assigned the case by the head of the review unit, and he rejected much of OPR's findings with regard to the individual prosecutors. Instead, Berg's review determined that the problems in the Stevens case were part of the mismanagement and poor organization of the case by the Public Integrity Section. While Berg's findings were ultimately overturned by the head of the review unit who sided with OPR, his findings raise interesting questions about the failed mismanagement of the case. Berg's findings deserve particular attention for two reasons. First, he has been nominated by the President for a position as a federal district judge of the Eastern District of Michigan. And second, he led the U.S. Attorney's Office in the Eastern District after a scandal similar to the Stevens case, when a major post-9/11 terrorism prosecution was dismissed because of discovery issues. So his judgment on this shouldn't have been lightly overturned. All three reviews reach different conclusions, but point to the same problem: a fundamental failure of justice attorneys to follow the rules required by department, courts, and the Constitution. So here we go from here. So where we go from here is the focus of today's hearing. Senator Murkowski has introduced this Fairness in Disclosure of Evidence Act, a bill designed to reform the discovery and disclosure process in criminal cases. We will also hear about her proposal from representatives of the legal community that have offered different views. I thank Senator Murkowski for putting forth a proposal and looking forward to hearing from her and discussing it with our third panel of experts. Justice's conduct in the Stevens case definitely warrants Congress's attention. However, I'm not sure at this point the legislation to completely overhaul the criminal justice system is necessary. I do have letters here from the National Association of Assistant U.S. Attorneys and one from Deputy Attorney General George Terwilliger expressing concern, and I ask that those be put in the record.
Objection.
I have concerns that changes to ex parte orders could have dangerous impact by discouraging their use as a means to balance between defendants' rights and protection of sensitive information. There could be unwarranted disclosure of classified information in national security cases, such as terrorism and espionage prosecution. Further, these changes could impact witness safety, as it could require justice attorneys to provide evidence that could be used to harm or intimidate witnesses, a sad but true reality of high-profile criminal prosecutions. Where I think we can all agree is that reforms are needed at the Justice Department, and I support Senator Murkowski's efforts to achieve reform in the department. I believe the failures in the Stevens case were not simply just a couple of line attorneys making bad decisions. So that brings me to something I've been crusading on for a long time. I've been concerned about the double standard of discipline at the Justice Department and FBI. As recently as May 2009, a DOJ Inspector General found that, quote, a perception of a double standard of discipline between higher ranking and lower ranking employees continues, end of quote. This perception was backed by the Inspector General's findings that senior executives at the FBI had OPR findings reversed 83% of the time compared with lower level career employees who had their findings overturned 18% of the time. While no similar review of Justice Department OPR findings was conducted, it's easy to see with OPR report in the Stevens case how this perception continues. Another area of concern for me with justice is the growing list of high-profile failures in the public integrity section. Just last week, a jury found former Senator John Edwards not guilty on one count and mistrial declared on 5 others. Then there was a prosecution of state legislators in Alabama that ended in 2 acquittals, a hung jury, and allegations from the judge that the governor's witnesses were racist. Add to this list the Stevens prosecution, the failure of the prosecution of Governor Blagojevich, and a pattern appears. However, this pattern is not a recent trend and dates back to the 1990s. At that time, the Public Integrity Section was unwilling to prosecute cases when the FBI presented evidence of campaign finance violations in the Clinton administration. It looked the other way when the FBI director concluded that the law required the appointment of an independent counsel. The Justice Department disregarded or disagreed based on frivolous legal analysis, keeping the cases within DOJ, but then refusing to prosecute. Hearings were held in the Senate, and poor mismanagement of the Public Integrity Section was documented 15 years ago. Clearly, something must be done at the department to address the failures of the Public Integrity Section, the double standard of discipline, and the discovery failures. Department Attorney General Cole is here today on our second panel to talk about a remedial effort taken following the Stevens case and ongoing efforts to correct the problems. I'm not sure that these efforts will be enough, and we may need to act in Congress. That is why today's hearing is so important. Thank you very much.
Thank you. We'll begin.